I, as minister, was advised by a review board that comprised a former director of public prosecutions, a former Supreme Court judge, a former or retired senior police officer. They advised the minister doesn't come to his position on appeals on his own. He receives advice from the review board. And in fact, in one of the two cases, recall that I would have dealt with hundreds of cases of appeals during my 4+ years as minister. In one of the two cases that they, after sieving through those 100, could come up with, the review board actually recommended to return 3 licenses to the individual, and I acted more conservatively. I believe there was no need for the person to have 2 handgun licenses, and I reduced it from 2 to 1. So in all cases, I not only acted within my ministerial discretion, but I acted upon the advice of the officials of the ministry or of the review board, which was comprised to consider all the evidence, consider all the information available, and make a recommendation.
Hold on. Explain something first, please. The review board of which you speak and whose opinion you acted on, yes? Was this the duly constituted review board of the FLA or that which was set up in your ministry, the Protective Security Unit, headed by Lincoln Allen at the time?
There's a unit within the ministry that does a lot of the administrative work for the minister, but there's a statutory board,
right,
that advises the minister on appeals. That is the one that's is established by the Firearms Act, and the act itself prescribes the type of person who should sit on that panel. Mm-hmm. And in fact, the panel that I had...
Well, that is a panel that you relied upon.
That's the panel.
The statutory created review board.
As well as the officials in the ministry.
Both?
Yes.
So they acted separately in coming to the recommendation that you
Lincoln
acted
Allen
on.
and his unit would summarize the file for the minister, including whatever recommendations were from the investigators, whatever came out of the FLA, whatever came out of the various units of the JCF, etc., and put all that together to bring to the minister for consideration.
So they acted in concert with the statutorily created review board.
Correct.
That's what you're saying?
Yes.
So in other words, they overlapped.
I wouldn't say so, because the review board was not based in the ministry. The ministry didn't provide administrative support to the review board. In fact, the review board sat at the FLA, although it was separate from the FLA.
Right.
I think the FLA provided sort of secretarial services for the board, and they used that conference room. But they're independent.
Mm. And you would have you recall the circumstances of this case, person PB2 X51, by way of an NIB report dated January 10, 2011, it was revealed that the applicant was arrested and charged in the U.S. for the offenses of trafficking cocaine, 4 counts of larceny, and grand theft. His firearm license was revoked on September 2012 by Scott, McIntosh, and Harvey on the basis that he misrepresented himself to the FLA and could no longer be considered fit and proper to be issued with a firearm. His criminal record was expunged after the date of the NIB report. By way of letter dated October 28, 2014, it was indicated that Mr. Peter Bunting, then Minister of National Security, granted the issuance of a firearm license to this same person. Given that the basis upon which his firearm user's license was revoked was now void, the FLA board withdrew the revocation. Who expunged, or which agency expunged this criminal record?
This was in Florida. The charge was based on the time that the person spent as a student in Florida, and the expungement certificate came from the judicial system in Florida. And what is interesting there, it was an expungement of the record of him being charged. There is no evidence that he was ever convicted on those offenses. That was, if you read the document, at no point it says that the person was convicted. What he had expunged was a record of his being charged. So in this particular case, there's not even any evidence of the applicant being convicted previously. But in any event, expungement entitles somebody to being in the same position as they were had they not committed those offenses.
And you felt comfortable giving him a permit?
For two reasons. One, that the same authorities in the jurisdiction where he was charged felt that he qualified for expungement of his record, which reinstates him to how he would have been before. And secondly, quite frankly, the whole principle of expungement is that there must be a path to remediation for persons, in this case a young person who may have made a mistake. We still have no confirmation of whether he was convicted or not, but who may very well have made a mistake. And there is a path to remediation for them.
And he was now engaged in activities that merited a firearm?
Well, he was granted a license in the first place because this was an appeal and a revocation. So I can assume that he was granted a license because he was a businessman, as I recall. So
How old was he at the time?
I can't remember his exact age, but I believe he was in his 30s.
Was he a constituent of yours?
No, he was not.
Oh. The other person, and I'm reading again from the Integrity Commission's report, by way of an NIB report of April 12, it was revealed that the applicant molested a little girl who is related to his wife. However, the matter was not reported to the police, and therefore no action was taken against the applicant. A CIB report dated December 3, 2010 revealed that the applicant was arrested and charged for the offense of indecent assault. His application was denied on January 24, 2012, and on the basis that the applicant was interviewed and found unfit to be armed and was subsequently approved on April 11, 2014 for firearm user licenses for a .38 revolver and 12-inch gauge shotgun by Justice McIntosh and Mr. Scott and Mrs. MacDonald Barker. By way of letter, dated July 25, 2013, it was indicated that Mr. Peter Bunting, then Minister of National Security, granted the issuance of a firearm license for a .38 revolver, a shotgun, and denied a firearm user license for a 9mm pistol to the said person, X50. Why? Explain.
Because again, first of all, that person had never been convicted. There was an allegation, but untested, uncorroborated, that he had molested a relative of his wife. And the review board, having evaluated the case, felt that the 3 firearm licenses should be returned. In that particular case, where I deviated from the review board's recommendation, I didn't see the need for the person to have 2 handguns. And so I only approved the 38 and the shotgun.
Mm. And this is against what the initial panel said, that he was unfit to be armed.
But that is why the law provides for an appeal, because the basis on which they made the decision was simply, in a sense, hearsay. Somebody had said he had molested. There was no corroboration of it. And to the extent there had been charges arising all in the same year, which from my recollection, there were some domestic disagreements in his household. And the 2 charges that were brought against him were dismissed. So there was no criminal case. The only so-called adverse trace was an investigator had spoken with someone, and they had said that he had molested his child's relative. And there was no corroborating. It had never been reported to the police. It had never been tested. I ask you, would you want Cliff on such a flimsy basis for your
I don't
career
know.
to be impaired?
I don't know if it's a flimsy basis. I don't know. I'm not in possession.
Somebody
of
just
all-
says something, it's hearsay, no charge, no investigation, no report, no charge, no investigation. I mean, if that was the case, then all of us could be exposed
But in the
to any
context,
allegation.
Mr. Bunting, of our realities in Jamaica, where the gun is a weapon of choice, in so many crimes, in particular murders, yes, it would seem to me that it would be prudent to err on the side of caution and say no. Why not?
Well, I would say in the vast majority of cases, I erred on the side of caution.
Mr. Bunting, I'd put to you the issue, why the discretion in these two instances? Security forces tell us that, listen, it is guns that Jamaicans are using to kill Jamaicans in record numbers. Huh? And here you are, a minister with discretion. That's your legal right under the law. Yeah? People are upset. Jamaicans are upset over it. I want to hear you talk to those Jamaicans, to explain, to tell them why they should give you the benefit of the doubt now and not say, go.
Well, first of all, the murders that we're suffering from in Jamaica are not being committed by licensed firearm holders in the overwhelming main. I would have to think long and hard to come up with murders that were committed by licensed firearm holders. The vast majority are by illegal guns. Secondly, in evaluating these appeals, you're looking at a number of sometimes conflicting recommendations. So, for example, in the case you spoke about of
Conflicting
the recommendations, yes, by the different investigative bodies. So, for example, you talk about the NIB, that there was an NIB report of indecent assault.
April 2010.
Right? On that same case, the FLA investigator recommended that the applicant is fit for the granting of such license and that he had previously held and maintained an impeccable record. And given the nature of his employment, the applicant should be favorably considered. So you're weighing up sometimes conflicting recommendations from different agencies. And this is why you have a panel of eminent persons, former DPP, former Supreme Court judge, former senior officer, to assist the minister in reviewing these appeals. So it's, in all cases, I endeavored to be fair, generally speaking, to be conservative, but in the same way, you speak about it being a high crime country. We have to ask, do these persons have a right to defend themselves? There was an outcry about a couple murdered who operated a supermarket in St. Elizabeth because their son had been denied an application even though the business dealt with a lot of cash because they did not establish the need to be armed. Now, in a country which has had the unenviable reputation of having one of the highest murder rates for decades, I think there's a prima facie case for our citizens to have a right to defend themselves.
Not cocaine traffickers, criminals, murderers, and ex-convicts, though.
I'm not saying that. And in no case did I issue a license to someone who was convicted or reported to be involved in any of those crimes that you spoke about.
So let me ask you this. Given where we are this morning, yes? Should Mr. Montague go, as he has?
I'm sure Mr. Montague knows, and the Prime Minister knows why he has had to resign. It's a 245-page report. I have so far primarily focused on the areas that affect me. There are scores of cases that the Integrity Commission has highlighted. Only 2 involve my discretion as Minister. And of course, I've primarily focused on those, even though I've scanned the entire report. But I think there is,
But if it's 2, it's too many.
No, Cliff. The law gives me an obligation as minister to hear these appeals and to make my best judgment. Now, you may or may not agree with the position that I take. You may or may not agree with how I exercise my ministerial discretion. But does that make it improper? No. There's nothing in here that suggests that my ministerial discretion was exercised in any but an appropriate way.
Mm.